Hello, this is Professor Smith with the College Level Examination Program's Introductory Business Law Course Review. This will be Contracts Part 2, picking up exactly where we left off. So an integrated contract is a contract that represents a full, final, and complete record of the parties' agreements. This is also known as a complete or total integration. A contract written is completely integrated and parole evidence is inadmissible. A contract is written does not need to constitute if a contract is written, it does not constitute complete integration and does not complete, then parole evidence is admissible. The four corners refer to the type of examination done by courts, and this is looking only at the document itself, the four corners of the document. Some courts expand beyond this and assess other evidence to determine if the contract is integrated. Condition is an event that is not certain to occur. A contract is subject to a condition when the performance is contingent on the occurrence of that uncertain event. If the condition is not met, no party has a duty to comply with their obligations. The absolute duty to perform does not arise until the condition has been met or executed. There are three types of conditions. Condition precedent, a condition that must occur before a duty to perform arises. Condition concurrent, a condition that arises at the same time of performance, or condition subsequent, a condition that cuts off a pre-existing duty. When a condition is executed, a party has the immediate obligation to perform. However, an excuse may arise and may come in the form of many different sorts of reasons. One could be a hindrance, which is when a party presents a condition that prevents a condition from occurring or fails to cooperate in order to ensure the occurrence of a condition. Another could be one party's breach material of a contract will excuse a condition such that the breaching party's obligation is deemed absolute and thus is considered a total breach. Another could be one party's anticipatory repudiation of a contract will be an excuse of a condition such that the repudiating party's duty to perform becomes absolute and cannot be treated as a total breach. Can be treated as a total breach, I should say. Another could be one party's substantial performance. This is of a condition. One party's substantial performance of a condition will excuse the lack of complete performance of the condition. The last could be if a party for whom the condition was designed to benefit agrees to a waiver by indicating with words or conduct that they will not insist on the condition, then the condition may be deemed excused, but it must be supported by consideration. If the condition is material, a waiver can become effective without consideration only if the non-waiving party detrimentally relies on the waiver. This could be excused by the estoppel. We're then going to move on to breach of contracts and remedies. A breach is when the promisor fails to perform in accordance with the terms, in essence, and a failure to perform represents a breach. However, the promisee's remedy may differ. Partial or trivial breach is if the promisor substantially performs under the contract. If the breach is minor but intentional, some courts may consider it to be material and thus non-trivial. When a breach is trivial, a promisee can bring a suit to recover damages related to the breach, but is not entitled to suspend their performance. A material breach arises is when an issue arises that is so central to the contract that it significantly impairs the contract's value to the promisee. If the breach is material, then there has not been substantial performance. A material breach allows that the promisor can bring up a suit to recover damages and allows the promisee can defend their performance, allows the promisee to suspend their performance, and it gives a way for the promisor to cure the breach. For a breach to be considered a total breach, it must contain the factors of either a likelihood of care, further delay will prevent the promisee from making alternative arrangements, or prompt performance is a critical element of the contract. All total breaches are considered material breaches. A total breach will discharge the promisee's obligation, allowing them to withhold performance and terminate the contract, as well as bring a suit to recover their damages. A promisee is allowed to seek alternative arrangements to fulfill the contract. A breach can only occur when performance is due and cannot occur before. In anticipatory repudiation we talked about before, this occurs when a party makes clear that either by word or by conduct they do not intend to perform, or that they will only perform under certain circumstances that go beyond the contract. When there is an anticipatory repudiation and the indicated inaction will be serious enough to be considered a material or a total breach, then the non-repudiating party can halt performance and treat it as a total breach until there is retraction. A party may retract a repudiation by indicating a willingness to perform under the contract. A retraction is not valid if the repudiating party has either materially changed their position in reliance on the repudiation or indicated their willingness to treat the repudiation as a total breach. Demand assurance can be performed when one party is uncertain of the other party's performance. This involves a written request of reasonable assurance regarding a party's intent to perform. The requesting party may treat failure to receive adequate assurance within a reasonable amount of time as an anticipatory repudiation and thus a total breach. Many remedies for such a breach exist, but the primary purpose is to compensate for monetary losses. Expectation damages will be granted to a party as a remedy and generally is in the amount of loss that represents what would have been gained if the breach did not occur. This is also known as restoring the benefit of the bargain. Expectation damages are comprised of damages in addition to consequential damages. Direct damages are referred to the difference between the value of performance of a party should have received and the value of performance that they actually received, while consequential damages are the losses that result from the transaction that are dependent upon the breached contract. The consequential damages must be reasonable, certain, and foreseeable. A party's damages award will be reduced by any costs that they could have avoided as a result of the breach. This is known as the duty to mitigate. The duty to mitigate actions that would have severely dampened the amount that you lost. So damages in essence for a breach will equal direct damages plus consequential damages minus any cost avoided or loss avoided. Reliance damages refer to the damages that represent the amount of money a party has spent in justifiable reliance on a contract, and these must be reasonable and foreseeable and are subject to the duty to mitigate as well. Restitution refers to the amount of benefit one party conferred on the other. The amount of damages reflecting unjust enrichment. This is not permitted. This is not limited to contract price. This does not get reduced by the amount of money a party would have lost on a contract, and restitution is meant to prevent unjust enrichment and not awarded in reference to the contract. Recession and restitution refer to the party's ability to terminate the contract and then seek damages for unjust enrichment. These damages are designed to put parties in a position as though there were no contract formed. When the contract is voidable, these are general remedies. Specific performance talks about reflecting an order from the court to perform the contract pursuant to its terms. This is not granted by courts, but will be awarded. This is not often granted by courts, but will be awarded when the damage remedy is inadequate. The equitable need for such performance outweighs the burden of supervision and the harm to the defendant. Courts will not order specific performance for contracts involving personal services. In cases where specific performance may not be appropriate, courts may issue an injunction. An injunction is an order prohibiting a party from engaging in a certain conduct. This will be issued by courts if either the damage remedy is inadequate or the injunction is necessary to prevent irreparable harm to the non-breaching party. When talking about a breached contract, the court will likely issue an injunction to prevent the breaching party from performing to a third party's actions that will have been obligated to perform to the non-breaching party. Some contracts stipulate the amount to be paid when a breach occurs. Courts will only award this amount if the following conditions are met. And then these are known as liquidation damages. If the following conditions are met, that consists of damages were difficult to determine or estimate at the time the contract was formed, and the stipulated amount represents the foreseeable forecast of the amount necessary to compensate the non-breaching party for their loss. If a court finds that the liquidated damages are unreasonable, then the stipulated amount will be construed as a penalty and will be unenforceable. Generally, punitive damages, non-economic damages, and attorney's fees are not recoverable. That is, punitive damages, non-economic damages, and attorney's fees are not enforceable. Now we can talk about bars to breaches of a contract and defenses to enforcement. So many defenses to enforcement of a contract exist, of which lack of capacity and statute of frauds constitute valid defenses. Talked about those before. Duress represents the following: an improper threat, as well as it leaves the victim no reasonable alternative but to comply with an agreement. If a party enters into a contract under duress, the contract is voidable by the part of the victim. Modern courts count broad threats or an intent to conduct an unlawful or wrongful activity as duress. A contract modified under duress may also be voidable. The victim, however, must demonstrate that they protested to the modification for it to be valid, while also proving they had no reasonable alternative. Undue influence refers to situations where one party takes unfair advantage of another to persuade them into entering a contract. This has two factors, which include a relationship of dominance pursuant to which one party has a strong influence over another party. Because either A party is in a weakened state, or B, there exists a fiduciary or other relationship of trust. And then the other factor in undue influence would be the dominant party unfairly persuades the other party to enter into a relationship. A mistake is something that is an error about a fact in existence at the time the contract was made. A contract entered into on a mistake is a voidable contract, and two forms of mistake exist. One is a mutual mistake, which means a party can avoid enforcement, which means that a party can essentially avoid enforcement based on the mutual mistake, given that a mutual mistake consists of both parties making the mistake. The mistake concerns a basic assumption on which the contract was made that has a material impact on performance, and the party seeking to avoid performance has not assumed the risk of the mistake. The other type of mistake is a unilateral mistake. This is involving a party's ability to avoid enforcement on the unilateral mistake if they can demonstrate that one party had made the mistake. The mistake concerns a basic assumption on which the contract was made, and that had a material impact on performance. They must demonstrate that the party seeking to avoid performance has not assumed the risk of the mistake, and equities favor avoidance. If the mistake was unilateral, only one person is mistaken, and it is more difficult to avoid enforcement. The parties seeking avoidance must demonstrate that not only will they suffer a severe hardship if the contract is enforced, but also that the other party will not suffer any harm if the contract is not enforced. Misrepresentation refers to an assertion that is not in accordance with facts. An expression of opinion can be the basis for misrepresentation if the speaker suggests they have knowledge of facts upon which the opinion is based. They have no knowledge of facts that would refute the opinion. In order for a misrepresentation on the basis to avoid a contract, it must show the following: a misrepresentation was made and it was material. If it's material, it is likely to induce that a reasonable person to agree the contract or not. Or if the person making the misrepresentation knew, they should have known that it was likely to induce a specific party to agree to the contract. The seeking party the party seeking avoidance reasonably relied on it is the last thing that needs to be shown for misrepresentation to be able to void a contract. Fraud refers to a form of misrepresentation, but made specifically with intent to misrepresent. Schneider is a misrepresentation made with knowledge of its inaccuracy, and unconscionability refers to or will be deemed when a court believes that a contract is so one-sided and unfair that it would be unconscionable to enforce it. There are a couple of different types of unconscionability, and really a majority of them fit into two categories. Substantive unconscionability, which exists when the terms of the agreement are grossly unfair or unduly favorable to one side. The other is procedural unconscionability, which focuses on the relationship between contracting parties and exists when one party's lack of choice regarding whether to enter the contract or not, or when otherwise exists gross inequities in the bargaining positions between the parties. When the contract is presented in a take it or leave it format known as adhesion, it is likely that a court would find procedural unconscionability because of the inability to bargain in that case. In order for a contract to be voidable under unconscionability, a court must find both substantive and procedural unconscionability. A contract will be unenforceable after a statute of limitations has expired, and this is the period by which a person may bring their claims. Varies, but is generally around 6 years, and under the UCC, Uniform Commercial Code, is 4 years. Once the statute of limitations has expired, a contract action is barred by the operation of law. However, the promissor's agreement to perform their obligation after the expiration of the statute of limitations will be sufficient to create a new contract, and the consideration of the past contract will be consideration sufficient enough for the new contract. A discharge of contracts is what we're going to be talking about next. And if a party is under immediate duty to perform, the contract must be discharged by either performance or by some excuse of performance. In some cases, they will allow for excusal due to changes in circumstances, which entail 3 essential doctrines: the doctrine of impossibility, the doctrine of impracticality, and the doctrine of frustration of purpose. Impossibility refers to a discharge by which these events occur. An event occurs after the contract is executed. An event must be proven to be unforeseen to be under this category. Impossibility could occur when the non-occurrence of which a basic assumption of the contract. It could occur when an event makes contract performance impossible, and the party seeking discharge does not assume the risk of non-occurrence. The next is impracticality. This is a performance if impractical. If it is impractical, it is unduly burdensome, pursuant to which performance could not occur without some significant loss or hardship. It's impractical for you to do. An event occurs after the contract is executed, the non-occurrence of which was a basic assumption of the contract. The event makes the contract performance impractical, or the party seeking discharge does not assume the risk of the non-occurrence. The last could be the frustration of purpose, occurs when the exchange loses most of its value as the result of the event, such as the contract is destroyed. Such that the contract is destroyed. This occurs when an event occurs after the contract is executed. This occurs when the non-occurrence of which was a basic assumption of the contract. This occurs when the event frustrates the material purpose of the contract. And this occurs also when the party seeking discharge did not assume the risk of the non-occurrence. Rescission will discharge a contract, but can be mutual or unilateral. A mutual rescission occurs when parties agree to rescind the contract, but in order to be valid, must be executory with respect to the parties, meaning that there is still some performance obligation, must be supported by consideration. The other is a unilateral rescission, when one party decides to rescind the contract. This is allowed if the party seeking to rescind has legal grounds to avoid enforcement by demonstrating undue influence, fraud, or duress. Novation is when a party assumes the obligation and benefits of the contract, thus discharging the prior contract. This requires 4 things: a previous valid contract, the agreement by all parties to the new contract, an intention to immediately terminate duties under the previous contract, as well as a new contract that is valid and enforceable. Unlike assignment or delegation, novation extinguishes rights and liabilities of parties under the previous contract. Sort of like putting Novocaine on a previous contract. You sort of numb it up and you have no former allegiance to it. Accord is something that represents an agreement pursuant to which the original promisee agrees to accept different performance from the original promise in exchange for release of the agreement. And an accord does not discharge the additional obligation under until there has been satisfaction. And satisfaction is the actual performance of the accord agreement. Both accord and satisfaction are necessary to discharge a contract, and our last topic of discussion will be illegal contracts and public policy concerns. An illegal contract is a contract that violates a law or a statute, and this renders a contract void and generally unenforceable. In pari delitto, when a court leaves parties to figure out themselves in a legal case, given that they are both guilty, but if it falls to one side, a court may use discretion and apply an appropriate remedy. Some contracts are not illegal but violate a specific public policy, and a public policy is a policy that is clearly defined in some statute or legislation. And a contract that violates public policy is not necessarily unenforceable, but instead courts must balance policy concerns with equitable concerns. And this involves considering the seriousness of the misconduct, this involves the nature of the policy, and this involves the relative guilt of the parties involved. Courts generally use discretion if restitution should be awarded in the cases of public policy violation. That has been us finishing our subject on contracts for CLEP Introductory to Business Law. So thank you folks very much for sticking with it, and thank you very much.